Picture this: a quiet afternoon, and then suddenly, someone hands you an official-looking document. It's stamped, formal, and a little intimidating. At the top, in bold legal language, is a word you've probably heard in movies or courtroom dramas: subpoena. Instantly, it feels serious, almost ominous. But have you ever stopped to wonder, what exactly does that word mean? And more intriguingly, why is it called a subpoena in the first place? The answer takes us on a fascinating journey through centuries of language, law, and power. Let's explore right here on History of Simple Things. The word subpoena doesn't come from modern English at all. In fact, it has its roots in Latin, the ancient language that has shaped much of the legal terminology we still use today. Subpoena is derived from the Latin phrase subpoena, which literally translates to under penalty. Right away, this gives us a strong clue about its meaning. A subpoena isn't just a polite request. It's a command backed by consequences. If you ignore it, you may face legal penalties such as fines or even arrest. The very name itself carries that warning: comply or face the penalty. To understand how this term became embedded in legal systems, we need to go back to medieval England. During this time, the legal system was evolving and courts were beginning to formalize procedures for compelling people to appear and provide testimony. The Court of Chancery, one of the key courts in England, played a major role in shaping this process. Unlike other courts that relied heavily on rigid rules, the Court of Chancery focused more on fairness and equity. It needed a way to ensure that people would show up when required, and thus the concept of the subpoena was born. Originally, a subpoena was a writ, which is a formal written order issued by a court. These writs would command individuals to appear before the court or produce evidence. The phrase subpoena was included to make it clear that failure to comply would result in punishment. Over time, the term itself, subpoena, became shorthand for the entire process. What started as a phrase embedded in legal documents eventually evolved into a standalone word that represents one of the most powerful tools in the legal system. As the English legal system spread across the world, particularly through colonization, so did its terminology. In countries like the United States and others influenced by English common law, the subpoena became a standard part of legal proceedings. Despite changes in language and culture over centuries, the word itself remained largely unchanged. That's why today, even though most people don't speak Latin, we still use this ancient term in modern courtrooms. There are actually different types of subpoenas, each serving a specific purpose. One common type is the subpoena ad testificandum, which orders a person to appear in court and testify. Another is the subpoena duces tecum, which requires someone to produce documents, records, or other evidence. These longer Latin phrases might sound complicated, but they follow the same pattern: clear instructions, backed by the authority of the court, and reinforced by the idea of under penalty. What makes a subpoena so powerful is not just its wording, but the authority behind it. When you receive a subpoena, it's not a suggestion, it's a legal obligation. Courts rely on subpoenas to gather information, ensure witnesses appear, and ultimately uncover the truth. Without this mechanism, it would be much harder to enforce participation in legal proceedings. Imagine trying to run a trial where witnesses could simply choose not to show up. Justice would quickly break down. Interestingly, the intimidating nature of the word subpoena is part of its effectiveness. Because it sounds formal and unfamiliar, it commands attention. People instinctively recognize that it's something serious, even if they don't fully understand its origin. That sense of authority is deeply tied to its Latin roots and centuries of legal tradition. It's a reminder that the law is built not just on rules, but on history and language that carry weight. In modern times, subpoenas are used in a wide range of situations, from criminal cases to civil disputes and even government investigations. They can be issued by judges, attorneys, or certain government agencies, depending on the context. While the process has become more streamlined with technology, documents can now be delivered electronically in some cases, the fundamental concept remains the same. A subpoena is still a command, still backed by the threat of penalty, and still rooted in that ancient phrase, subpoena. However, it's worth noting that subpoenas are not unlimited in their power. There are legal protections in place to prevent abuse. For example, a subpoena can be challenged in court if it is considered unreasonable, overly broad, or intrusive. This balance is crucial. While the legal system needs the power to compel information, it also must protect individual rights. The evolution of subpoena law reflects this ongoing tension between authority and fairness. So the next time you hear the word subpoena in a movie or see it mentioned in the news, you'll know there's more to it than meets the eye. It's not just a legal buzzword. It's a term with deep historical roots, a direct connection to Latin, and a clear, powerful meaning: under penalty. That simple phrase has traveled through centuries, shaping how justice is carried out and ensuring that people cannot simply ignore the law. Thank you for watching. If you have suggestions for our next video, feel free to share them in the comments below. We'll be sure to give you an acknowledgement for your contribution. Thank you for joining us on this journey through the history of simple things. Don't forget to like, subscribe, and stay tuned for more stories woven through the smallest details.